Good morning, good afternoon, and good evening, depending on your time zone, and welcome to the first set of our expert panels on Climate Law and Governance Day 2022. This is Advancing Climate Litigation Worldwide, hosted by the Asia Pacific Center for Environmental Law at the National University of Singapore, Melbourne Climate Futures at the University of Melbourne. Without further ado, I'd like to hand over to the chair of this session, Professor Jacqueline Peel, who is a leading internationally recognized expert in the field of environmental and climate change law. Her scholarship on these topics encompasses international, transnational, and national dimensions, as well as interdisciplinary aspects of the law-science relationship in the environmental field and risk regulation. She is currently the director of Melbourne Climate Futures, the university's climate change initiative. Professor, over to you.
Thanks so much, Tejas, for that introduction, and welcome to everyone joining us online from different parts of the world for this seminar. We're really excited to be speaking with you tonight about, well, tonight from my time zone, but morning from many others, about advancing climate litigation worldwide. I'd like to begin, as is customary in Australia, by acknowledging that where I'm coming from is the traditional lands of the Wurundjeri people of the Kulin Nations, and I pay my respects to their elders past and present, and extend that respect to any Indigenous or First Nations people joining us online for this session from the different parts of the world where you are located. The background for this panel was thinking about the recent Intergovernmental Panel on Climate Change report, Working Group 3, which I was the lead author on and which one of our panelists, Joanna, also contributed to. And it's finding for the first time around the contribution of climate litigation to overall climate governance. But even though the IPCC talked about climate litigation in that report, it had very little to say about the impact that litigation was having and how much of a contribution it might make to governance now or in the future. So we thought that this panel, which has a diverse range of academic experts and practitioners from around the world, could offer some insights on what's that kind of impact might be and how we might envisage the governance role of climate litigation. I think that's incredibly important during COP27 in Sharm El Sheikh in Egypt, given that a lot of the discussion at the moment is focusing on loss and damage, compensation and potentially liability. So I'm just going to introduce each of our panelists, and then I'll start by posing a question to all of them to respond to, then go into more discussion questions. If you have your own questions during the session, could I encourage you to put them into the Q&A? And those will be forwarded to us, and we'll try and get to as many questions as we can during the session. So joining me on the panel tonight, I'll just go around and if you don't mind, panelists, just waving as I mention your name. I'm not going to do extensive biographies, but these people are incredibly well qualified to be speaking to you on these topics. So first up, the co-host of the session, Associate Professor Jolene Lin from the Asia Pacific Center for Environmental Law at the National University of Singapore, and a colleague with whom I'm currently engaged in writing about Global South climate litigation. Next, Associate Professor Joanna Setzer from the Grantham Research Institute on Climate Change and the Environment at the London School of Economics. We also have Professor Louis Kurtz from the Faculty of Law, Northwest University, and many other places, Louis. Although we don't have, as advertised, Alice Garten from FILE joining us, we have wonderfully in her place David Barnden, who is from Equity Generation Lawyers in Melbourne, Australia, and one of the leading lawyers taking forward climate litigation here. So I thought I'd start with a general question to all of our panelists, and it's framed around the question of what is climate litigation's contribution to governance. But Joanna, I might go to you first for the sort of perspective on the global trends, since that's something that LSC does particularly. In that sort of setting, what sorts of contributions is litigation making to our broader field of climate law and governance?
Thank you, Jackie, and hello everyone at COP and beyond. So I was very happy that Jackie invited me to be part of this panel, not only because it was a chance to be among so many colleagues that I admire and really enjoy working with, but also because I really like that discussion about the outcomes of litigation and exploring the what it means also that the APCEL gave so much attention to litigation for the first time in its last assessment report. So before that, I wanted to give some high-level trends that come not only from our global trends in climate litigation report that we published back already in July, but also from a newer report that we published just a month ago that focuses on framework litigation. And also, I'm delighted to announce, I don't know if you already came across that announcement, but delighted to announce a new partnership between the LSE Grantham Institute, the Sabin Institute at Columbia University, and Climate Policy Radar, sorry, children background, and Climate Policy Radar, CPR, which is bringing us together to bring AI, artificial intelligence, into the search of all the laws, policies, and soon also litigation. And that really means that from now on, and increasingly, we are still in a transition phase, but we will be able, and all the users will be able, not only to search the summaries of cases and laws, which was the case, you know, until now, we wrote summaries and then the search was only there. But from now on, users will be able to search in any document through PDFs and also in any language, because the machine automatically translates any language into the English, for example. So that means that if you want to look for precautionary principle, everything that has that in any document will show up. And that's very exciting. It's very different from the manual way in which we have been doing things so far. So I wanted also to use this opportunity to announce that, because also that's very connected to the Global Trends report and the analysis that we do. And it will allow us to look at better at the trends that we already analyze. So that was my first announcement. Now, what I want to do in my very short 8 minutes probably left is that I want to bring some of the global trends that are of relevance for this panel. So the first point is that we know very well, and I think people who have been working in this field have already seen many times that graph that shows how climate litigation has increased significantly in the last years. So our graph starts in 1986, when in the first case that was that we know of, but then there's very, very little until 2015, really, when this picks up significantly. And since 2015, we see not only a sharp increase in litigation still in the US, but also outside of the US in many other countries in the world. So 2021, which is the last year that we looked in our global trends, is the year with the highest annual number of cases outside of the US. And this geographical distribution is already quite interesting. Now, the other interesting trend that I would like to highlight is that whereas that first graph looks at all the litigation in the world, we try to do something which is, not perfect, but it is to separate the strategic litigation, which are the cases that receive most media coverage and which tend to also to receive most attention from the literature. It doesn't mean that those are the only type, of course. It's a small number of cases that receives a lot of attention, but we try to understand what litigation is brought beyond the interest of the direct parties involved, what litigation is brought with the aim of trying to shape corporate behavior, increase accountability from both governments and corporates. And that graph, again, is quite interesting because you see the graph starts around 2007, and then it really peaks now after 2019, especially 2021. What is important, however, is also to remember that not only these cases are one part of climate litigation, but also that strategic litigation can be brought with aims that are anti-climate, as some would say, or that will try to weaken or hinder climate legislation, climate protection. So it's an alert that we always try to remind people about. Now, we said that the aim of this conversation was to look into outcomes, and that conversation is always a very complex one, because of course it begins to how you define outcomes. Are you thinking about outcomes, impact, effect, effectiveness? So there is a whole terminological discussion to begin with, and then of course there are the direct and indirect outcomes, which Jackie and Harry very well already called our attention in their early book in 2015, that you have the direct and the indirect impacts. And what we try to do when we look at the global trends is that we try to look at the direct impact. So we look at what the case, for example, it is brought as a case that is pro or anti, and the decision, is it a pro or anti? So we try to do that analysis, which we know it's limited. It's only to do with the grounds of the case and the decision, and only with the cases that have been decided, which it also is a smaller number of cases. And when we do that for litigation outside of the US, which also is a smaller number, but it gives an indication of what have been the direct outcomes of many of these cases. So the last Global Trends report has an interesting, quite a bit different from the previous year, because we found that still a bit more than 50% of the cases have outcomes that are favorable for climate action, but that number has dropped from the previous year, a lot to do with a number of cases that were unfavorable to climate were the subnational cases in Germany. So you see how these decisions that might still be challenged and appealed might make the analysis very not very accurate in overall, but temporarily this is what we have. So these were 11 of 13 cases that got dismissed, and the graph already drops a bit, just to explain that. So, well, that's the direct outcomes. We are also, of course, very aware of the many more indirect outcomes. And I would say that the IPCC, recognizing that climate litigation shapes potentially climate governance, is a really important moment in this wider international recognition of the role of litigation. So if you had the chance of looking at the IPCC assessment report that was published in April of Working Group 3, Mitigation, you will see that not only there is a paragraph for climate litigation in the summary for policymakers, which we know is a big deal to get all countries to accept that one paragraph that recognizes and the text is the role that litigation plays affecting the outcome and ambition of climate governance. But also, I would really recommend that you look throughout the report. If you do a Control F, you will see that there are, I think, 130 times that the word litigation appears. And those appearances are in chapters 1, 4, 13, and 13 has a whole subsection on litigation, and also 14 and 16. So out of 17 chapters, many chapters will now engage with litigation in different ways. So that's my probably more than half already of what I wanted to say, but now just finishing this short talk, I wanted to emphasize some trends in litigation against corporates and against governments. So in litigation against corporates, in our last report, we did an analysis that I found quite interesting. We looked at all the cases that had been filed around the world against corporates and what sectors were involved. And this was a surprise, because we know that litigation against carbon majors has increased significantly in the last years. Since 2015, it has increased. Interesting, if you look at that, it has increased much more outside of the US than in the US in the last 2 years. So this is already interesting. But also, if you break down in sectors, you realize that actually now you have more than 50% of cases in other areas, and the last year specifically, you have an increasing in numbers in litigation in the mining, media, clothing, energy, especially in the transport and finance sectors, and food and agriculture. So I think that diversity of sectors that are now involved in corporate litigation against corporates, it's something really to notice and to explore further. And my last point regards litigation against governments. And this is the report that I mentioned that we published recently. It's a report that we only analyzed a subset of cases that now we call government framework litigation. We used to talk about, refer to these as systemic litigation, sometimes ambition litigation, and we can discuss later. We ended up, for several reasons now, talking about framework litigation, which also connects to framework legislation, which many of these cases deal with. So in looking at this subset of cases, we identified until July 80 framework litigation cases, 80 of what some people also will call agenda type cases, 80. That's a really massive number. And these cases have been filed against governments all around the world. In 24 countries, we have identified cases like that, and also the General Court of the European Union, the European Court of Human Rights, the Inter-American Commission of Human Rights, UN Committee on Rights of the Child, and other UN special procedures. So half of these numbers alone have been filed in 2021. And you see, therefore, how this type of litigation has increased. Just to finish on this type of litigation and finish my talk, we identified these cases as doing two different things. One, there are ambition cases, so they deal with the absence or adequacy or design of a government's policy to climate change. And the second is that they deal with the implementation. So these implementation cases concern the enforcement of existing climate protections and trying then to get governments to meet the targets or implement existing plans. There are also many interesting questions that we can pose, thinking about, well, you would imagine that we start with ambition cases and then move into implementation, because after all, governments would have designed or come up with policies and legislation. That's not really the case. We see still both. There's an interesting mixed picture there. But the outcomes of these cases, and this is how I finish with the outcomes theme, is that still 47 of these cases have already been decided. If you look at all that group of cases, again, you have the issue with the German cases that make the total number of favorable decisions being 16 against 30 unfavorable. But if you look at only the national level and only at cases that have reached Supreme Courts, so framework cases that have reached apex courts, out of 9 cases heard by apex courts, 7 have been decided favorably. So 7 cases have made all the way to Supreme Courts, and they have been favorable to climate protections. So I finished there, and I'm looking forward to the rest of the conversation.
Thanks so much, Joanna. I think that's given us an excellent overview of the broad trends. We might go sort of more granular now. And David, if I turn to you, we're talking about climate litigation and its role in governance, but I think that raises really the question, why litigation as a tool? So I thought I'd put that question to you, and also invite you to talk about the types of cases that you've been involved in bringing, which I know have had a focus on corporations, and reflecting the trends that Joanna was talking about, a focus on a different sector rather than carbon majors, in fact, looking at financial sector corporations. So why litigation, and how's that shaping up in the sort of corporate litigation space from your perspective?
Thank you, Jackie, and thank you everyone for having me today. First of all, I'd like to acknowledge the Gadigal people of the Eora Nation, the traditional custodians of the land, and pay my respects to elders, both past and present, and I extend those respects to First Nations peoples everywhere. Why litigation as a tool? Look, we represent a range of clients. One of our more notable cases was on behalf of 8 children who sued Australia's Environment Minister when it was considering approving a coal mine extension project. And at its most basic level, the children wanted to instruct us so they could do something. They were frustrated. They were striking on Fridays from school. They organised over 300,000 people in 2019 to strike against the Australian government's ineffective climate policies, or non-existent really. There's a general frustration out there, not just by younger people, but also by investors, by shareholders, by people who are even accidental investors, so pension fund members everywhere. So that's where it starts. But in terms of its practical impact as a tool, it enables evidence to be put before the independent courts, particularly in Australia, of climate change harms, and it enables both scientists, policymakers, health professionals to ventilate their professional opinions and concerns, which often reflect and do reflect the IPCC in general, and give that legitimacy. And particularly in jurisdictions where there has been a history of media pushback against climate action, which has been notable over the past decade or more in Australia. It's been a really important avenue to get that out, and to not only that, it exposes what governments aren't doing and do not need to do. The particular case with the 8 students was around a duty of care to avoid harming children when a Minister for the Environment would consider approving a coal mine. Now, it seemed to us and to most of the Australian public like a very basic duty, but it was one that didn't exist. And so in this case, there may not have been direct outcomes as a result of the case, but it certainly raised the profile and brought home to the Australian people what else they needed to do to impact government decisions. In terms of a focus on corporate actors and in particular the finance sector, we see shareholders, retail shareholders and bigger institutions very concerned about climate change and how their investee companies are dealing with it. Our journey on this started with 2 investors, retail investors in the Commonwealth Bank of Australia. In 2017, they were concerned that the bank wasn't dealing with climate change risk. Their first concern was that it didn't recognise it as a material risk. And once it would do so, that would create obligations on the directors to deal with the climate risks and come up with a strategy on how to do so and how to protect those investments. That case was successful in that it settled in 2017, and the bank went on to disclose to investors what it was going to do. One of the things it did do was come out with a climate policy in 2019. That particular policy said the bank would not finance new oil or gas projects unless they were in line with the goals of the Paris Agreement. The same shareholders we represented in the first case discovered 7 new oil and gas projects that the bank had financed despite that commitment and despite going to the AGM and questioning the chair of the bank and asking her how it assessed compliance with the goals of the Paris Agreement, there was no answer. So, or no valid answer. So again, these investors are suing the bank, accessing internal documents, and there's a really big indirect governance impact from that case, where shareholders can access board minutes, documents around systems, and it will change the face of corporate governance in Australia when it comes to climate. I might just mention one other case against investors that we ran was on behalf of a very, very young pension fund member who sued his pension fund Rest for not managing climate change risks. That was very hard fought litigation over the course of 2 years, which settled on the steps of the court, and it revolutionised the way this fund dealt with climate change risks. The settlement disclosed the new commitment to net zero, a scenario analysis for investments against a well below 2 degrees scenario, and this single court case had a major impact on what the board thought about climate change and how that permeated through its risk management procedures. So we do see really good results from climate change litigation, particularly against private actors, particularly by investors or accidental investors. And it really changes the whole litigation landscape and whole corporate governance landscape in Australia, and particularly at a time where there was no leadership from government and investors and corporates were simply following along. So we're encouraged by climate litigation. We also acknowledge the breadth of work that's going on around the world, as can be seen by Joanna's research, and salute the brave clients and hardworking lawyers out there. And I think I might just finish off by mentioning a case which actually has an overlap of investments and the behaviour of state actors, where a 23-year-old law student sued our Australian government for not disclosing climate change risks to sovereign bonds. And so the implications of this case are huge. The case is ongoing. There is a really interesting dynamic where most of Australia's sovereign bonds are held by foreign investors, central banks, hedge funds, pension funds, and the likes. And when they create their own ESG policies, they take control from Australia and increase the cost of capital, increase the cost for Australians to borrow money to finance healthcare and other public services. And it's the indirect impacts of that case may have already been felt, where the government last year announced a net zero goal when it was lagging, and in and around the same announcement acknowledged the increase in borrowing costs for sovereign bonds as a result of climate change risks. So we really do see a lot of results from framework litigation, from corporate litigation, and from climate litigation in Australia.
Thanks so much, David. That's really interesting. I think we might return, if we can, later to that question of outcomes and whether we're seeing more from certain types of litigation. But I thought I might turn now to you, Jolene, because I think one of the other trends that's highlighted in the reports that Joanna's mentioned is that climate litigation, which once might have been seen as a sort of preoccupation of the global north, has well and truly now spread to many countries throughout the global south, and an accelerating number of cases being brought. So Can you tell us a little bit about what we're seeing on climate litigation in the Global South and whether that's making a different kind of contribution potentially to climate law and governance?
Thanks, Jackie. Thanks, everyone, for all the amazing insights, which have been really interesting and generating lots of thinking here. Yes, so as Jackie has mentioned, what are we talking about draws on the work that both of us are doing for a book where we are looking more deeply into climate change litigation in developing countries of the Global South. So the one thing that I'll share a couple of our findings for now and possibly to address the bigger question of impact. So what we see is that, so the project, the genesis of the project was really because a lot of the discussion and literature, both academic literature and practice, and practical discussions by practitioners tended to focus on examples in developed countries. And in fact, there was once I attended this webinar looking where this person said, a very well-known professor said, I can see why there might be litigation in Africa. I might see why there's litigation in Latin America, but how can there be litigation in Asia? And I was like, okay, that's how it made me start thinking about, really? So anyway, Jackie's and my qualitative analysis shows that climate change litigation is occurring and has occurred. So cases have been filed and decided in Global South jurisdictions in Asia, in Africa, and in Latin America. So and amongst these three geographical areas, we're looking more in depth into what we call the front runner jurisdictions, the jurisdictions where the most number of climate cases have been filed as well as decided. So just based on the numbers, we've decided that we'll focus on these three jurisdictions. In Asia, the country that has had the highest number of climate litigation or highest amount of climate litigation is India, especially because a lot of their environmental public interest litigation is occurring through the National Green Tribunal, which is a specialist environmental court and has dealt with various environmental law cases that have climate change implications. In Africa, by far, it will be South Africa that has the highest number of cases, and in Latin America, it would be Brazil. But cases have been filed in many other countries, including Ecuador, Colombia, Argentina, and in Asia, we have cases in Nepal, Pakistan, the Philippines, Thailand. What are some of the characteristics of these cases? One of the things that we have found is that there's a prevalence of rights-based claims. Many of the national constitutions of the Global South jurisdictions contain the right to environment or the right to life that has been interpreted judicially to include the right to a clean environment. That has been a really widely used basis for much of the litigation in Global South countries. There is also the preference for the enforcement of laws and policies that already exist, rather than pushing for new or better climate laws. We hypothesize that one of the reasons for this is that a lot of the environmental laws on the books already provide familiar laws that allow environmental lawyers to use case law and precedents to address the court, while there still is a little bit of a gamble, right, to put forward a novel argument that may be used to advance what would be more of a core case in climate change litigation. So we see a lot of preference for the enforcement of laws. For example, one of the landmark cases coming out of Pakistan was the case of Lahari, decided in 2015. As a landmark case, it was actually a petitioner approaching the court seeking a judicial pronouncement that the government had failed to put into practice or to implement its climate change programs and policies that they had already developed, but had passed through the necessary governmental channels, but had not implemented in practice. Another thing is also that plaintiffs might be trying to address what they perceive to be more fundamental drivers of climate change, such as deforestation in the Amazon. We are using this term we use this term stealthy climate litigation. This idea that litigants are advancing cautiously and quietly by packaging climate change issues with less controversial claims. And this might be done to dilute the political potency of climate issues, and the idea of that these issues raise the equivalent of the political question doctrine. And this is also in recognition of the fact that climate change litigation is not without its risks in many global south jurisdictions where environmental defenders face physical and legal threats in their work and to their personal safety as well as their families. So when we talk about impact, I think that one thing that is really interesting at the moment is that we have a couple of examples where we can use process tracing to show that the impact, there is that impact. However, what is more difficult to document, particularly in the global south jurisdictions that we're looking at, is that many of the enforcement is a challenge. It's one thing to get a victory in the courtroom. It's another to get those victories put into practice. So, for example, there is a relatively recent judgment by the Indonesian Supreme Court that found the government negligent in its handling of the transboundary haze that has led to terrible air pollution in Jakarta. And it combines issues of right to life, right to health, as well as just traditional negligence in a tortious sense. But that judgment has been not been enforced, and this is not terribly uncommon. However, we make arguments that there are still benefits to bringing litigation in developing countries, and that there is still a role for litigation to play in improving accountability and governance for climate change in the global south.
Thanks, Jolene. And I should have furiously been taking notes so that I can write the next chapter of our book, but I'm sure that our colleagues have been doing so in the background. We've sort of gone down into the detail, but I want to zoom back out now with the question to Louis, because Louis, your work is usually more focused on the big picture of governance, and particularly the project around Earth system governance, of which climate is one part in terms of the planetary boundaries that we might be crossing with our unsustainable activities. So in that sort of zoomed out context of looking at governance as a whole, where do you see litigation fitting, and what kinds of changes in governance do you think are needed really to deal with the sorts of crises that we're seeing, with climate change being one of the ones that's most in view for us here on the call and as COP27 progresses?
Thank you very much, Jackie. Thank you very much also for this invitation. Lovely to be sharing this panel. And that's obviously always the benefit of kind of speaking last, is because you can draw on all of the wonderful insights that have already been given. And I do want to build on what has been said, and perhaps just very briefly reflect on some of the broader issues surrounding courts and the impact of courts on global climate governance within the context of the planetary emergency and the climate emergency, Jackie, as you say very correctly, that we are in. And I think it's a point of departure, picking up from Jolene's point of the very political nature also of climate conflicts and of cases before courts, is as a general statement to say that many specific functions, of course, can be distinguished that courts fulfill in a generic sense. They've got the authority, of course, to administer justice through the interpretation and application of laws. They adjudicate legal disputes, they resolve conflicts, they provide legal remedies, they protect fundamental rights and freedoms, as we also heard, especially in the Global South. They uphold the rule of law. And ultimately, of course, courts protect the integrity of a legal system. And they perform these generic functions, especially also, as we have heard in the context of climate change, by providing access to justice, determining and not deferring climate claims, upholding the rule of law, taking and forcing the executive, legislative, and the private sector to actually take climate change seriously, and so forth. But I think it's important also to remember that while courts are, of course, formally a part of government, they are also very unique in the sense that they do not strictly resort under the traditional notion of so-called political actors. They rather serve as gatekeepers of justice while performing a critical oversight role in supposedly, of course, neutral and apolitical way, which in turn affect and shape broader governance processes and trajectories. And in the climate context specifically, courts enable a broad range of interested and affected stakeholders to use a state's adjudicatory tools, as David has also said, by serving sort of legal platforms or judicial conduits through which certain aspects of climate governance could be facilitated. And in so doing, courts offer, I think there seems to be general agreement on this, a very important arena for various actors to confront and interact over how climate change should be governed. And this, of course, we need to recognize is also an attempt to control, order, or influence the behavior of others in relation to climate governance. And this growing influence of the courts, as Johanna has also said, specifically in the global climate governance constellation, I think lies in 5 domains. And we are busy in a draft paper, which Johanna is also involved with, unpacking these, and hopefully it will appear soon. And these 5 domains where we really can see the influence of courts in global climate governance is in the domain of accountability, the way that courts redefine power relations, the way that courts remedy vulnerabilities and injustices, the ways in which courts use and interpret international climate law, and how courts use climate science to adjudicate legal disputes. And I just very briefly want to say something about each of these 5 areas, if I may. In terms of accountability, I think it's accepted that courts perform an important function in the climate context by imposing accountability both on public and private sector actors for their failures, specifically, to take adequate action on climate change. And this is so because courts are in a very unique position, of course, in terms of the separation of powers and the 3 spheres of powers, and more so perhaps than any other branch of government, to be sure, to bridge the ever-widening so-called accountability gap in climate governance. The accountability, of course, of private corporations can be sought based on the emissions directly caused by these corporations, but also by reference to the emissions that corporations cause or enable beyond their own operations, for interest, for example, by selling fossil fuels. And an example of a rare success case here was Milieudefensie versus Royal Dutch Shell, of course. The accountability of government authorities can relate to their own emissions, for example, through their infrastructure investments, military activities, or ownership policies, or of course to their failure to implement climate action. And this, I suspect, is where the main center of focus lies within the climate litigation discourse. And there's an increasing number of successful cases that can be identified that relate to the regulatory aspect of public sector accountability. The case of Agenda versus Netherlands, of course, is very famous in this respect. In terms of the redefinition of power relations, we see that courts could affect power dynamics in politics at the local, national, and possibly even at the global level, especially where low-lying island states are using increasingly international fora to also adjudicate and to climate concerns and conflicts and try to get redress for their own claims. And from this perspective, certainly courts are empowering, we see various stakeholders to have a say in the making of climate policies, also simply by allowing them standing in relevant cases. And this has a range of benefits. One of this is, of course, because it has the potential to decentralize and democratize power in global climate governance, notably to the extent that courts bestow new political roles onto communities, NGOs, social movements, and of course citizens generally, by allowing them to very directly confront governments and corporations. And in several cases, NGOs and citizens have successfully challenged a political determination by a government accountable to a national parliament, and hence, of course, voters, concerning the requisite level of mitigation action. The Neubauer and others versus Germany is one such an example. Third, in terms of addressing climate vulnerability and injustices, Jolene has already referred to this. It especially occurs, we see, in the global south context, where human rights are used and relied on predominantly. And courts can, of course, remedy these vulnerabilities and injustices associated with climate change, or at least contribute to greater political recognition and social awareness of these issues that could augment efforts to address global patterns of climate injustice. And as we see, climate claims related to the impacts of climate change on future generations, on global justice, and on human and non-human welfare can often only be brought to courts through very narrow concepts of rights claimed by or on behalf of plaintiffs. And this is especially evident in the youth movement, where youth claimants have frequently sought to act as proxies for claims about intergenerational justice as a subgroup more vulnerable than the general population, of course, to the long-term effect of greenhouse gas emissions. Fourth, in terms of increasing the reach and impact of international climate law, one important function of courts is to interpret and apply international climate law, and this could lead to better compliance and stronger climate ambition or action. And this point is obvious, of course, for international courts, whose function is to apply international law. But we see most of the action here, of course, at the domestic level, to the extent that it applies to national courts, even in dualist as opposed to monist jurisdictions, where international law does not directly form part of the law of the land, but should be incorporated into domestic law. And I think one of the clearest examples of a court really relying and getting their hands dirty with climate, with international climate law, and using that as the basis to inform its decision is the German Constitutional Court decision of Neubauer. And finally, with respect to climate science, I think the need to align global governance with Earth system science is increasingly recognized. And we see this, Jackie, as you also mentioned, in terms of the confluence, increased confluence and multidisciplinary interactions between Earth system scientists, lawyers, and political scientists, especially political theorists, and so forth. This need also plays out more specifically in the domain for climate science to inform, shape, legitimize, and improve global climate governance. And courts certainly have an important role to play in the ongoing endeavor to augment the climate science policy governance interface. And I think it's fair to say that science plays a central role these days in climate change cases, with several courts relying on scientific evidence to assess the causes of climate change, its impacts, potential response measures, or strategies. And this is important because in law and policy making, having a baseline understanding of climate science and the capacity to engage with technical scientific material is and should be seen as a critical foundation for the development of successful climate protection policies. And again, In my view, one of the best examples of a court engaging really with climate science is the German case of Neubauer. So a final word, I think the idea that courts are increasingly asserting themselves as influential actors in global climate governance is a very appealing idea. But we also need to recognize the limitations of this, because using the judiciary to influence global climate governance is still a relatively new phenomenon with numerous ongoing cases, as we've heard, some with positive and others with negative outcomes, as we've also heard from Joanna. And of course, still insufficient empirical evidence that could show how courts are really contributing to global governance in concrete ways. And I would certainly love to see more studies empirically showing how courts are practically shaping global climate governance. But that said, although it's unlikely that courts will offer a silver bullet, of course, for the climate crisis, certainly not in the short term, or be recognized as very powerful climate governance actors on the same footing as parliaments or executive authorities, I think many courts are not shying away from asserting themselves more deliberately as actors that actually have the power to influence global climate governance. Thanks.
Thanks, Louis. Those are excellent points and a great summary of the sorts of different ways in which climate litigation may be feeding into the broader governance of the problem. I just want to remind our audience who are being very shy, although I can see they're all online, that if you do have questions, pop them into the Q&A and we'll try to get to those soon. But before I do that, I might just invite our panelists to give some quick responses to a question that I'll pose. I think we've reflected quite a lot on litigation as a tool that's seeking to influence how climate litigation is governed. And Joanna, you picked up the thread around the fact that a lot of the cases that we're seeing have a strategic framing. So there's a deliberateness to the way that they're being brought to try and produce this influence. So I just wanted to explore in that context of litigation perhaps becoming more strategic in its intersection with climate governance, where our panelists think that there is the most the best outcomes being achieved, what evidence there is, going to Louis' point, and also if there are limitations of using litigation. So it's kind of where are we seeing the most outcomes, where are we seeing perhaps some potential limits, and where is the evidence or perhaps the gaps that we most need to address. So Joanna, that's a huge question. I'm going to ask you just for a few reflections, and then I can see some questions are coming in. I'll give the other panelists a chance to respond, then we might go to some questions. Thanks, Joanna.
Thanks, Jackie. And I think I would start from exactly a point that Louis made about the need for more empirical research that understands impacts and outcomes of litigation. Even maybe before that, we need to also research that understands where to look, how to measure, and that discusses these different methods. So, for example, I'm interested in both qualitative and quantitative ways of understanding impact. There is an ongoing piece of research that I'm involved in with colleagues at the Grantham, a bunch of economists trying to understand if there are impacts in to share prices of litigation brought against carbon majors. And if that is the case, you would see how not only litigation is creating a reputational damage that can be quantified, but also potentially that could in itself bring more litigation, as shareholders would show that their interest is being affected as shareholders by the dropping in value in these companies. So this is an example of where through interdisciplinary research, we can also explore different types of outcomes. Again, where Louis comes in, I think political scientists and anthropologists, they have much to contribute in understanding these impacts. As an example, I would mention the work of Noah Crawford, who is an anthropologist who worked a lot with the Liuya case in Peru, and he also explored in his research how the community in Huaraz dealt with that all of a sudden being on the spotlight in the media coverage and documentaries about the village that otherwise very few people would know, and how litigation created within that village also some issues between among the community. So I think these examples just show how not only we need to understand impact, but we need to understand from many different perspectives, disciplines, and methods. And this is what I would love to start seeing more and more, because there's really now not only more cases, but more time has gone by that allows us to start looking also across time. It's another issue of impacts that it's not just about before bringing the case while the case is ongoing, but also as the case finishes even. So I think these would be some of the points that I wanted to make.
Thanks, Joanna. I think in the interim, we've started to have a deluge of questions coming in. So I might go to some of those and join up two related questions that are asking the panel to think about adaptation-specific litigation, or litigation that might be also occurring in the food and agricultural sectors. So often when we do talk about litigation, the focus is on mitigation, emissions targets. The framework litigation that you mentioned, Joanna, often has a mitigation focus. But what are the trends that we might be seeing in the adaptation space? And indeed, what more can we do to take forward climate adaptation litigation, particularly to address issues of impact on land and food security issues, which of course are a really important part of dealing with the massive impacts of climate change for many parts of the world, particularly in the most climate vulnerable nations. So if you'd like to respond to that question, just let me know. I don't know, Jolene, if it's something you'd like to talk about first.
Sure, Jackie. So the idea, so a lot of the cases have, of course, well, at least in the global south, many of the cases do focus on mitigation. And I think it came as a bit of a surprise to us actually in our initial work that we were expecting perhaps to see a bit more cases on adaptation. But I think that part of the reason for this is also how cases are selected for bringing forward. So what do I mean by that? Like when there are so many possible cases that could be brought and funded. But then the question is, with these limited resources, which cases do we focus on? I think that adaptation is definite, and loss and damage are two areas that we will see more funding and support for litigation moving forward, especially because we've talked, adaptation has been a bit of the neglected sibling of mitigation in the UNFCCC framework for quite a long time. And the Paris Agreement was supposed to put our minds to adaptation and to recognize that it needs to be happening. But I think like in these 1 or 2 years, we've seen some really powerful natural events. I mean, not powerful events that clearly show that the impacts of climate change are upon us. I mean, the research on Pakistan, the floods that happened this summer. In Pakistan, the floods were a combination of two trends. One was increased monsoon, and the other was the melting of the glaciers. And these two came together to create one of the greatest human tragedies in Pakistan amidst a period of great political instability. And the research has shown that the impacts were actually worsened by at least 50% because of climate change. So I think these are really, really powerful examples that will bring people's attention to the need to use all sorts of measures, including adaptation, including mitigation, litigation, to push for better adaptation, particularly because the poor, the marginalized, and the vulnerable communities are the ones who are most affected, and resources are not reaching them.
Thanks, Jolene. David, I might bring you in here because there's a question around sort of the Australian context where government behaviour is changing, and this might be the case in other countries as well, where you've had a recalcitrant government, for example, but then governments start to engage. How does that affect any kind of climate litigation strategy in the context of maintaining a strategic focus?
Well, yeah, governments, at least in Australia, are improving. There are notable things that they're not doing, though. In Australia, we have a new Climate Change Act, which addresses domestic emissions. As one of the largest exporters of coal and gas in the world, our government isn't doing anything about it, or doesn't appear to be doing anything about it. So there's plenty to do. But you're right, we do see, in terms of the domestic situation, a desire to have a national policy on electric vehicles, which goes to some litigation we have against an individual state in Australia. So yeah, it is encouraging, but there's plenty of strategic opportunity there.
And this might be a related question, or Louis, you might like to come in here. There's a question around, who it's easier to oblige to do things through using a litigation tool. And I think it goes to your accountability point before, Louis, in terms of whether where this tool is more effective for producing accountability from private sector actors, who we know are very major emitters, or whether it's more effective against government actors, or if it's sort of different kinds of accountability depending on the sort of actor that we're looking at. So I don't know if either of you want to tackle that one.
I could perhaps just very briefly say that it's perhaps not a question of, and I would be very ill-placed to make a judgment on whether it's more effective against private companies or against governments, but I think it is increasingly, collectively seen at least, a very effective tool of keeping perpetrators accountable. And I think that the important examples are being set. And I think also that governments, that legislators, that private corporations are increasingly being more careful also, because they see these examples, they see what is happening, and they see that many courts around the world are not hesitating to enforce accountability. And I think that is where the power of this lies, is perhaps more in the examples that it sets, and the symbolic narratives that it creates, that carbon majors, for example, cannot and will not be allowed anymore, as far as possible, to continue with their destructive practices at the expense of a vulnerable living order. And perhaps just to get back to your earlier question, I think that one of the biggest challenges here is the David and Goliath question, and how to ensure that those who are fighting, especially carbon majors in the courts, are sufficiently empowered and abled and capacitated and supported to bring successful claims, because we know that the coffers and the resources of carbon majors are endless. Those of you, David, certainly in practice would probably be able to speak much more clearly to this. But it is at least, I think, that what we are seeing in terms of what is happening in the courts is that vulnerable people are empowered to speak up, and we would need to support that as much as we can.
I think we've only got a few more minutes left in the panel, and I'm loath to leave it on a negative note, but one of the questions has been around what the biggest challenges are, and indeed where you're bringing strategic litigation or test cases, if there's a risk around creating bad precedent or creating a backlash that in fact has a negative effect. Let's try and turn the negative into a positive. What's perhaps in your final sort of comments, which I might invite you each to make, the biggest challenge, but also perhaps the biggest opportunity for climate litigation to play an effective role in climate governance. So I'll go around our panel room. Joanna, would you like to start?
Sure. So trying to be very brief. First, I think that in strategic litigation, there's always that risk and that fear of having a negative precedent. And human rights strategic litigation faced the same for many years. Environmental litigation, health litigation. So if you think about, the tobacco litigation, all of these types of litigation have dealt with the challenges of having bad precedents, sometimes for decades. So it's, of course, that's part of the game, but it's something that no one really wants, and ideally you want to minimize. So I feel that, first of all, it's important that in thinking strategic litigation, that the cases brought are really carefully thought, that you bring the best available science and engage and bring the precedents that exist from around the world that can support the case in the best possible way. So it's really about crafting and thinking and designing that case using the state of the art to at least know that from that angle, you're being as safe as possible. And then I think secondly is that even we know that lost cases have some impact, and sometimes positive impact. I think particularly looking at the corporate sector, how banks and regulators and insurance companies until recently really didn't care about what was going on in the world of climate litigation, and now how very much aware and paying attention. And anecdotally, I see that just from the kind of invitations that I received to speak and who is asking to have information about climate litigation. So this is all to say that sometimes even litigation that is not filed, but the risk of litigation is having an interesting impact in particularly corporate and regulators' behavior. So that's just to say that the risk of litigation is something of its own that also deserves some consideration.
I think we might be out of time, so I apologise to all those who've put their really interesting questions, and you might want to take them up with some of our panellists. And also to the other panelists who didn't get to contribute their thoughts on the biggest challenge and opportunities that I'm sure have many other ideas. I'd like to thank all of our panelists for joining us tonight. Joanna, Jolene, tonight, I keep saying tonight, it's morning in other parts of the world, but it's evening here. Louis and David, and thank you very much for your contributions and the excellent questions. And I think it's really reflected, this discussion, how much is going on in climate litigation. The variety of impacts that it might have, and the variety of contributions it's making to climate governance. So let's hope when the next IPCC assessment occurs, we're seeing a much broader evidence base brought forward and some really strong outcomes from that litigation. So thank you all for joining us, and especially to our panelists as well. Thank you.